Welcome to the Boston Barrister, Kevin Patrick Seaver, bringing you insights about your family and the world.
Welcome to the Boston Barrister. My name is Kevin Patrick Seaver, located in Boston. Karen Reed was charged with the killing of her boyfriend, whose body was found outside a Canton home in January of 2022. The first criminal trial was found to be a mistrial. In the second criminal trial, she was exonerated of all major crimes except for one misdemeanor. During the trial, the defense strategy for Karen Reed was to establish that other people had means, opportunity to harm John O'Keefe. In a joint statement by Jennifer M.C. Cabe, Brian Albert, Colin Albert, and Brian Higgins, stated in a joint statement to various newspapers that they've been harassed relentlessly. The four have claimed they've been subjected to relentless false allegations, harassment, as well as intimidation, which has been a campaign of lies. This lawsuit has been filed in Norfolk Superior Court. In response to this statement, Adam Kearney, known as Turtle Boy, went on X and then laid out all the facts that he laid out during this trial of Karen Reed. The defense for Karen Reed also made a statement and was indicating that lawsuit appears to be vindictive and retaliatory in nature, and that the jury has spoken. They've exonerated Karen Reed of the death in the criminal action of John O'Keefe. I find the most fascinating thing is that at some point between the two lawsuits, one by John O'Keefe's estate as well as by these other four who have recently filed in Norfolk Superior Court, that Karen Reed may have to take the witness stand under oath and testify, if not a deposition long before she testifies. But when I explained this to some of my colleagues that are not lawyers recently, a couple questions arose that they couldn't figure out. And the first question was, why does double jeopardy not attach to these civil actions, since Karen Reed's already been found not guilty by a jury of her peers in Norfolk Superior Court already? And that's a great question that a person asked me recently, and the answer is very simple. Double jeopardy is where you cannot be tried twice for the same crime. There's a difference between criminal charges, which must be determined by a very high evidentiary standard called beyond a reasonable doubt, which mathematically is like 90% or better. After beyond a reasonable doubt becomes another standard called clear and convincing evidence, which is utilized when you have fraud on a contract or the elimination of visitation or the termination of parental rights. And that is an evidentiary standard they say is about 75% or higher to be proven. Now, the third evidentiary standard is what's called the civil standard, preponderance of the evidence. More likely than not, 51% or higher. And that's what the civil case is. Double jeopardy is only in a criminal case. You can't be tried twice for a criminal case. Once you're exonerated, that's it. There's no more trial in a criminal court where you could have the risk of going to jail and be imprisoned. In a civil case, the penalties are monetary in nature. You do not face possible jail time and going to prison. The second question that somebody asked me today is, why can't Karen Reed utilize the Fifth Amendment right to self-incrimination and does not have to testify? The Fifth Amendment right against self-incrimination and her ability not to have to testify only attaches in a criminal case. It is not something you can claim in a civil matter, which is what, again, these two lawsuits are. They're different than criminal. That leads me to my final point, which I said earlier. I am fascinated to hear what Karen Reed has to say under oath, whether by deposition, which may happen, or during a trial that would happen in Superior Court civilly. And I am sure I'm not the only one that wants to hear what Karen Reed has to say.